it seems I've run across a string of DIY estate planning documents gone awry in the last couple of days, and here's the latest victim. So, there's a married woman, husband and wife are living in a homestead, but the house is just in wife's name. Well, wife does a last will and testament that says she gives her home to her grandson. So first issue there is that in Florida, you cannot disinherit your spouse, even if your spouse is not on the deed of the home. Even if it was your premarital home, you've paid it off. Once you get married in Florida and that spouse of yours moves into the home and makes it their marital homestead, they have constitutional Florida homestead protection rights. So you can't just deed your property away from your spouse. So the first problem is she didn't know that because she did her will herself. And she wanted to leave it to her favorite little grandson. And when I say little, this kid's 9 years old. Oh, and by the way, the wife is dead. So the husband now is coming to me saying, hey, wait a minute, I'm still living in this house, and apparently it looks like it's owned by a 9-year-old once it gets through probate. And what does that mean for me? Well, the whole thing's a shit show, and it should have been and could have been avoided if someone would have done their estate planning documents properly and gone to see a qualified Florida estate planning attorney that would have told her, ma'am, I know you love your grandson, and hey, sure, he's awesome, but here in Florida, you can't disinherit your spouse, and it's a really, really, really bad idea to try and leave a piece of real property to a 9-year-old who can't legally own real property, or certainly can't manage property, can't rent the property, couldn't sell the property. They're too young to contract. And so even if this woman was not married and tried to leave it to a 9-year-old, the problem is that that 9-year-old's parents now need to go get a Florida guardianship over the property for their 9-year-old so they can manage the property for the 9-year-old until the 9-year-old turns 18. And more money, more cost, unnecessary. The proper thing to do if she wasn't married would be to put it in a trust, deed the home into the trust. You can have the 9-year-old as the beneficiary of the trust, but with a contingent minor's trust built in that says if my favorite grandson is under age 18 at the time of my death, that he shall not inherit the property outright, but it will be managed by my successor trustee for his benefit till he reaches age 18. But none of that was done. She had no idea what she was doing, but she didn't want to pay a lawyer to do her estate planning document. Well, in this case, we are building rockets, and now the shit has hit the fan, and so it's going to be a cluster getting it through probate. The husband is going to have an interest in the property. The grandson's too young to have a remainder interest. The whole thing is a mess. So take that for what it's worth. Have a great day.